The Speech Resource Company presents Historic Moments in Speech.
I'm Robert Wikstrom with another chapter of Historic Moments in Speech. This time we're featuring speeches by past and present justice members of the United States Supreme Court. The highest federal court in the country and the head of the judicial branch of government was established in 1789 by Article 3 of the U.S. Constitution, which permitted Congress to exercise and President George Washington to sign into law. It was originally made up of 6 justices who would serve on the court until they died or retired. The justices are nominated by the President of the United States and confirmed or denied by the U.S. Senate. The highest judicial officer is the Chief Justice, who's responsible for presiding over the court. The Chief Justice also presides over trials of impeachment against the President in the U.S. Senate, as was the case with Andrew Johnson, Bill Clinton, and Donald Trump, all of which were eventually acquitted. Recent cases of note before the court include Texas versus Johnson in 1989, which found that flag burning and other potentially offensive speech is protected by the First Amendment. Roe versus Wade in 1973, which ruled that women have a right to an abortion during the first 2 trimesters, which was overturned in June of 2022. U.S. versus Windsor in 2013, which revoked the U.S. government's ability to deny federal benefits to same-sex couples. And Obergefell versus Hodges, which in 2015 legalized same-sex marriage across the 50 states. Our first speaker, Justice Thurgood Marshall, became the court's first African-American justice. In 1961, President Kennedy appointed him to the U.S. Court of Appeals for the Second Circuit. 4 years later, President Lyndon Johnson nominated Marshall to replace retiring Justice Tom Clark as Associate Justice of the Supreme Court. After graduating from Howard University School of Law, in addition to starting a private law practice in Baltimore, Marshall began a 25-year affiliation with the National Association for the Advancement of Colored People in 1934. During that time period, he argued some 32 civil rights cases before the Supreme Court, including his most historic case as a lawyer, Brown versus the Board of Education, in which the court ruled that separate but equal public education was not applicable because it could never be truly equal. Marshall won 29 out of those 32.
Sample complete. Ready to continue?